The following video is based upon true crime content. Therefore, it may contain images and/or language that some find disturbing. For this reason, viewer discretion is advised. I'm muted again. Look at me. Look at me. Y'all didn't say anything because you're so used to it. You're so used to me being muted. Hello, everybody. How are we? Let me do this again. Good to see everybody. Welcome in. Am I muted? So we're going to pick up again and finish watching the hearing this week for Kouri Richins. And this is the hearing where they're trying to get a bunch of evidence suppressed on the defense side. It's called the Walk the Dog letter, and it was found in her cell. If you are wondering what's in that letter, I did read it on last night's stream, so you can go back and look at that. They brought up, we last watched the first detective in the case, who is now over in the K9 unit. She got up and spoke a little bit about, you know, when they did search warrants, when she spoke to the defendant, all this kind of good stuff. And then now they've got this second prison guard up on the stand, and they're going through this one. Well, I think there might have been 2 times when her cell was searched. Now, one time it was searched because they had said that something happened on the unit and everybody's cell got searched. And then another time, she had some kind of medical, they called it a medical issue. They never said what it was. And during that, they all went up and checked on her cell, and they ended up moving her to a cell below, like 1 floor lower. So they went and had to pull all of her stuff out. In doing so, they were also checking for some type of paper that she held up in like a, you know how when they have their jail calls with their visitors? She was like on a video call with somebody, and she held up a piece of paper, and they're wondering what was on that paper. So they were looking for that specific piece of paper, and in doing so, they found this Walk the Dog letter. Now, if anything looks suspicious, they have to go and they have to scan it in. And once it's scanned in, then they send it over to the attorney prosecutor's office and let them decide whether or not they need it. It went through the formal process, but her attorneys are now trying to just go through everything that they did to get to this letter and say that it was attorney-client privilege. It had her attorney's name on it. It had her attorney's, and it was an envelope with her attorney's name on it. But that's not what they're saying. They're saying it was just a random piece of paper or pieces of paper found in a book. So that catches us up. So let's get going.
I think there were nine pages. Did you take all 9 of the pages at that time?
I did.
So when you saw these pages that were in a handwriting, you read all of them, right?
I read most of the document on my way out because once I verified that there was something in there of concern, then I was taking them out of this section to take to my supervisor.
So the very beginning of that, in front of you, the first couple of lines, and you can just read it to yourself right now.
Okay.
Is about a conversation between Ms. Richins and her attorney, correct?
No. It's saying she's referred to this guy as the third person.
Right. She's talking about something that her attorney told her, correct?
Correct.
All right. So as you started to read this, you immediately saw that she was talking about something between her and her attorney, correct?
Correct.
But you continue to go on and read it?
Correct. So I scanned the document, and then fairly quick, she talks about basically what she's telling her brother to say.
Well, I understand that's what your interpretation of the document is, but let me back up a little bit. So when you come across documents that are privileged, do you typically go on and continue to read them?
They weren't marked as privileged.
When you come across documents about an individual's case that they've written?
We scan those documents just to look for safety security threats.
You scan them or you read them?
To scan them. Or you read them until you determine that it's a legal document when it's a handwritten letter that's not in a legal folder or anything like that.
Now, you refer to that as a letter, but is that a letter addressed to anybody? Does it say "Dear somebody" at the top?
No, not at the top. At the back of it, it clearly is addressed to her mom.
Well, wait a minute. Let's clarify here. Addressing a letter would, there's no, oh, sorry.
Go ahead, Mr. Bloodworth.
Like all the other documents in this case, it says what it says. We don't need a quiz on what it says.
Are there questions about why Sergeant Thomas did or didn't do whatever he didn't do next that you need to ask?
There is, and it's laying foundation for argument that will be made in the briefs.
If you need to ask questions about what he did or didn't do, that's fine.
Well, I think it's important to clarify, for purposes of argument and privilege, whether or not this document was obviously a letter.
Well, but you can, candidly, I don't care whether he thinks it was obviously a letter. I can address that, and I have to, under the law, make an objective determination of that. If you want to ask him why he did whatever he did or didn't do next, that's fine.
Okay. All right. Well, can I get an answer to the first question? Is there a salutation on the letter to somebody?
No.
All right. But you continued to read it?
Correct.
Anyway. And it's not signed on the bottom by Ms. Richins. It's not "Love Kouri" on the bottom, correct?
I would have to...
I'll go ahead and take a quick
Ms. Lewis,
look.
if you just ask the next question, I'm going to move you along just a little bit here.
Was there an envelope with that to mail it?
No.
Were there any letters in her cell that were ready to be mailed out that you found that day?
I don't recall any. This is the only letter I remember. This was the only letter of significance that I felt was a violation of rules and a safety security threat.
All right, and it was attached to 3 other pages that were just notes, correct?
Yeah, it was just like a checklist it appeared to be a checklist. I couldn't really tell you everything that was on it, on the last 3 pages.
Okay, but it wasn't you didn't think it was part of the first 6 pages?
Yeah, I thought it was part of the actual document, yes.
All right, are you aware that the next page, page 7, was found to be privileged by the taint attorney in this case?
No.
You're not aware of that?
No.
Okay, Your Honor, I just want to admit Exhibit 158 for the record. This is not a document that this witness would be familiar with, but I don't think I have any objection from...
What is it?
This is a letter from the taint stating that the 7th page of this document.
Okay.
Your Honor, the other way, of course, to read that letter is that the first 6 aren't.
Why? Either way, I don't have the 7th page in front of me, do I?
No, you don't. I can get it to you and we can submit it, but it was determined to be privileged, so the government doesn't have that either.
I've not seen it.
Okay.
The only one that...
Sure, I'm never going to rely on this, but we'll mark it, and you can
Well,
make
yeah, I just
argument.
wanted for the record that
Okay.
the documents this was found with were
It's been offered.
privileged.
Okay. 158 is offered.
Okay. Now, you said you don't recall if they were glued together at that time.
I do not remember them being glued together, no.
All right. Then if I could just also offer, I guess this would be Exhibit 159. Sorry, Your Honor. After discussing this with Mr. Bloodworth, I'm going to move ahead. All right, so
again, I have trimmed this down, guys, so that if there was any pauses or secret meetings during the trial or the hearing, we're not going to watch that.
the only thing that was taken from the cell was this 8-page, 9-page document, correct?
Correct.
And what did you do with the document after you took it from the cell?
I took it into the jail commander and explained the contents of the letter to him, which then I was referred to take it to the county attorney's office to verify if it was a legal document.
I'm sorry, can you leave more? I didn't hear that last part.
I took the letter out to the jail commander and discussed the contents with him, and then was referred to the county attorney to determine whether it was a legal document or not.
All right. And it was determined this is not the document that was held up to the video camera when Ms. Richins was visiting her mother that you were originally looking for, correct?
Correct.
So this is a different document that you took out of the cell.
Correct.
All right. And then the rest of her belongings were put, or I don't know if the rest of them, a number of her belongings were put in a bin, correct?
I wasn't there when that happened.
I think you were, actually. Why don't we put on video Exhibit 78 again?
Are we doing this to refresh his recollection?
Yes, but it's in evidence. I mean, all right. So you are in the cell when Sergeant Barrett takes the bin down, correct?
Correct.
And Alex, if you can back up more from where he comes from. Now, he comes from behind the door, correct?
Correct.
And those belongings are things that were behind the door, it appears, correct?
Correct.
But isn't that where the LSAT book is in that bin at this point?
I wouldn't know. I was looking at the document the whole time, so I don't even recall him taking that bin out.
Do you recall coming back about an hour later to take pictures of the LSAT book?
I do.
And where was the LSAT book when you took the pictures of it?
I believe it was down in that property down there.
It was in the bin, correct?
Correct.
And did you take that book out of the cell and put it in the bin?
No, I don't know if Barrett must have grabbed it, or if he grabbed it later and put it in there, or if he grabbed it like while I was reading the letter.
Well, shouldn't that be on the video? If he put more things in the bin?
Yeah, I'd imagine.
All right. Your Honor, you'll have the videos. So he doesn't recall. I don't want to just sit here and show every video. But
Well, to be clear, I don't know how many of these there are, but I'm not going to watch all of them unless you have determined that one of them is relevant.
all right.
You can just proffer which one you want me to watch, but
I'd like to proffer a negative. There is not a video of anything else being put in the bin after we see the bin coming
Okay.
down the stairs.
fair enough.
So, and there's only a few videos after this.
Okay.
But so there is a video, though, of you pulling the book out of the bin, correct?
Correct.
And taking a picture of it. All right. Your Honor, we don't have anything further. Thank you.
Mr. Bloodworth, any redirect for?
Take a look at that video. What is this depicting?
Me grabbing the book out of the bin
And why are you grabbing the book out of the bin?
so I could take a picture of where I found the letter.
And by book, you mean the LSAT book.
Yes.
And why did you want to take a picture of where you found the letter?
To book it into evidence or attach it to the report of where I found the letter,
Okay.
because I stated it in my report.
Is that the LSAT book in your left hand where you found the letter?
Yeah, it looks like it.
Is this you using your cell phone to take a photograph of that?
Correct.
And is that the photograph that, if you know the number, but is found at 86 in the court's binder? We can show you that photograph. Do we have it real quick? Your Honor, can I borrow the course binder to show? Okay. Sergeant Thomas, is the court showing you Exhibit 86?
Yes,
Is that the photograph of the LSAT book where you found the walk the dog letter?
correct,
And is that the photograph you took that was depicted in the video we just watched?
correct,
To recap, you found the walk the dog letter in the LSAT book, correct?
correct.
And you never searched a folder, a manila folder during that entire search we've just discussed?
Not that I recall.
You never
I don't
searched,
remember it at all.
and you never searched a folder with Ms. Lazzaro's name on it?
Negative.
And you conducted your search at the head of the bed?
Correct.
Head of the bed is about 6.5 feet from the foot of the bed where Sergeant Barrett was standing?
Roughly, yes.
No further questions. Thank you, Your Honor.
Ms. Lewis, may we release this witness?
Yeah, we may, yes.
Okay. Counsel, what's next?
Your Honor,
Your-
sorry.
It's still your floor.
We would just want to admit into evidence, which is State's Exhibit 107 and 108.
They've been offered. You'll
It's
have an
already been
opportunity
offered.
to tell me why they're
Stipulate to those, yes.
important.
Those are a recording and a transcript of said recording of a phone call between Ms. Richins and her mother, where she talks about that these 6 pages, the walk the dog document, were located in the envelope with the privileged papers. There's other parts of the conversation, but that's what we would be offering.
Proffer the date for me.
September 17th, I believe, 2023.
It's the 16th, Your Honor.
16th?
And then we have nothing further.
Okay.
Your Honor, the state, as to the same walk the dog letter motion to suppress, wants to call Detective Jeff O'Driscoll. The state intends to call Mr. Kochodimos, testify to the effect of, based on tons of training knowledge and experience with these types of warrants. This warrant is very typical of phone extraction warrants. In fact, it's more narrow than many phone extraction warrants that contain language simply like dump the phone as long as it has to do with the crime. And he can explain why warrants require that breadth. Now, I can see where that information would be unnecessary given the fact that this court has approved so many similar warrants and just probably knows that.
Well, the other issue that I think there's a scope of the inquiry issue that I have here is that the warrant was issued. It says what it says. Is there a legal route for collateral attack on its scope at this point?
So,
I mean, once it's issued, isn't the only routes of attack either that it was secured through fraud, that's a Frank's hearing, or that its execution was unreasonable? But as long as the information seized or secured is within the scope described by the warrant, is there a legal basis for the warrant was overbroad when issued kind of attack?
Your Honor, the state doesn't believe so. And to be clear, that the defense in their motion has not challenged the veracity of the probable cause under Frank's.
Understood.
The defense has not challenged the execution of the warrant. They are indeed challenging the 4 corners of the warrant as issued.
Help me understand, Mr. Ramos, what's your hook?
It's a lack of particularity described in what to search for within it.
And let's assume you're absolutely right about that, and that the judge that issued it missed it, wasn't sufficiently attentive. At this point, though, where we have, I believe, good faith reliance on an overbroad warrant, isn't it black letter law that that's not a violation of the Fourth Amendment?
Well, no, I don't believe so. If it was issued and it lacked particularity, Your Honor has the discretion to go back and either suppress it entirely.
Do I have that authority?
I believe you do, Judge, based on case law.
Okay. And you'll be able to cite me to that?
The way I've read it, yes, Judge.
Okay.
Now,
right.
that's assuming Your Honor believes it does, in fact, lack particularity.
Okay.
If it doesn't.
Well, I need to give you a fair opportunity to lay that foundation, though, and make your arguments.
Now, to be fair, coming into this motion or to this hearing, we were going to just submit on the four corners and just brief it. So I had no plans on calling anybody. However, I understand the state's position of wanting to call Mr. Kouri.
Candidly, I really don't care what Mr. Kouri thinks is typical. I mean, I'll wager with him about how many of these I've seen versus how many he's seen, and so I think I can make that call.
And the state's comfortable with that, Your Honor, because candidly, the court has signed warrants with identical language.
Yeah, probably so.
It is our stock language that we use in every phone dump warrant.
Right. But I need to give Mr. Ramos an opportunity to make his arguments, and so, yeah.
Well, that, Your Honor, I believe that opportunity will come in paper.
Yeah.
I'm happy to limit this based on the court's experience with such warrants to the four corners, not call Mr. Kouri and move on.
Is there any evidence you feel like the defense needs to put on to provide the record from which you can make your arguments regarding this warrant is infirm because of a lack of particularity?
Judge, I believe that I'm limited to the four corners.
Okay.
I don't believe I can present any evidence, even if I wanted to.
Understood.
Should he want to do it, and I'd certainly love a chance to cross-examine.
No, I don't.
Somebody.
Candidly, I don't think Mr. Kouri testimony on that issue is going to be particularly persuasive.
We would agree, Judge, and one thing we did discuss, which we would it's already been offered. I've discussed this with Mr. Bloodworth. In the initial motion that I filed, I identified some warrants. Come to find out later, there was another one that it just wasn't identified as through the IMEI number.
Okay.
So we've gone back and forth. All of the warrants have been offered. We're stipulating to them, and I'll cite them in the brief, but
Understood.
Just want to let Your Honor know.
Okay. All right. Mr. Ramos, anything else we need to discuss today regarding the motion to suppress electronic data?
No.
Okay. Mr. Bloodworth?
Nothing further on that motion, Your Honor. I think we can call Detective O'Driscoll in relation to the walk the dog motion. I think we can complete that before 6 o'clock. Your Honor, may I, Coach?
Please.
Handing Detective O'Driscoll a copy of 6-page walk the dog letter that is in the court's docket at 214. Detective O'Driscoll, I'm going to ask you some questions to ideally provide the court with some clarity regarding some of the discussion inside the walk the dog letter, okay?
Okay.
Your Honor, I'm going to object at this point. I don't see how going through this is going to be helpful to the court. Like Mr. Bloodworth's been telling us all day, what's in the letter, what's in the letter, the court can read it. The question here is whether...
Pause one moment. Help me out, Mr. Bloodworth. Where are we headed?
Sir, it's interpretation more than reading.
Why can't I interpret it, though, as well as this gentleman?
Your Honor, because some of the interpretation requires information that the court doesn't possess that Detective O'Driscoll has developed through investigation. Can I give you an example?
Let me ask you another circumstance question. Is it information that Sergeant Thomas had when he handed it over to the Summit County Attorney's Office?
No, Your Honor. It is information to decode, if you will, some of the coded pieces of the letter and to explain why to explain the meaning of the letter. And let me proffer why that's necessary,
Sure.
right? The defense in their moving papers have essentially argued that among an attorney-client, the letter is a attorney-client communication. They've also, I guess, alternatively argued it is attorney work product protected.
Right.
It can't be both. It can be one or the other. They've
Sure.
argued in the alternative. And their work product protection argument is essentially that this walk the dog letter, the defendant prepared it in anticipation of litigation or trial.
Or that it reflects a conversation she had with her attorney about those preparations. That the substance is attorney court work product, yeah.
Correct. All grounding in, we're doing this because of litigation and
Right.
trial. The state will make an argument in the future when we prepare our opposition papers that, no, the walk the dog letter was not prepared by the defendant in anticipation of litigation or trial. Rather, it was prepared by the defendant in anticipation of witness tampering and publicity. To make that argument, the court needs a deeper understanding of the walk the dog letter, who the various references are in the walk the dog letter, so that the state can make that argument.
And when you say references, are you referring to names, places?
Yes, names, places. So, you know,
Why don't we just ask those questions, Ms. Lewis? That's fine.
That's all the questions, Your Honor. I'm going to hold up so the court can see it. It's the highlighted pieces of the walk the dog letter that Ms. Lewis has.
The way to do this, to obviate the objection, is to the extent this letter says something to the effect of names a person named John Doe, just ask this witness, do you recognize that name? Does that person have any significance to this case?
Yes, Your Honor, that's the plan.
Okay. Ms. Lewis?
For the record,
Yeah.
just renew the objection that the letter can be read on its face for purposes of a motion to suppress.
Fair enough. Can you speak specifically, though, that there may be names or other references in there that you all recognize that I don't recognize or wouldn't when performing an objective review of the letter, because I don't have the same level of information that you all have?
I think that who these may refer to, I don't know what he's going to say, but may not be what we believe, what he believes may be something different. But now we're back to infecting the jury pool again. They're going to argue that these are coded words. Where he gets his information is certainly not from Ms. Richins, who wrote the letter. So we're going to put a whole bunch more stuff out there that Mr. Bloodworth was very concerned about.
With respect, it's already out there. This was all on the record. Gosh, we had a hearing about this. Ms. Lazaro was standing there saying the same thing, and I said something to the effect of, if they thought they had probable cause to charge her with witness tampering, they would have charged her with it, but we are where we are.
Ooh.
Everybody has their arguments. This has been out for a year and a half. Can we just get the factual information out, and then you'll all be able to make your arguments? But that concern was vetted a year and a half ago.
All right, I understand. I just have an ongoing objection to this.
I understand. Just ask factual questions.
Yes, Your Honor, and can we agree that the state has discretion in whether or not to charge
Sure.
if there's probable cause?
We'll see. Okay, let's keep moving.
Detective O'Driscoll, can you please turn to page 3 of the letter?
Yes.
In the middle paragraph, that reads, also please text Lotto or call, tell him, do not text me.
Yes.
Do you know who Lotto is?
It's Mike Kelly.
And who, at the time of the walk the dog letter, was Mike Kelly in relation to the defendant?
Close friend or intimate interest.
The letter then says, tell him not to text me. What do you understand that reference to text me to mean?
Text messages sent over the HomeWave system from the jail.
And did they have a history of texting over the HomeWave system from the jail?
Yes.
Everybody say hey to Michelle's boo, who's listening in for the first time.
Can you please turn to page 4?
I know they didn't introduce him, but I'm going to introduce him. This is Detective Driscoll. I think they brought him up twice during this because I seem to have 2 different things of this. He did not come onto the case until about a year into it, but he was on the case at the time that she was arrested.
do you see right at the top a reference to potentially working out mortgages for houses identified as hers, yours, and Chelsea's?
Yes.
The hers, you can tell from the letter, relates to Marissa's. Who is the yours in that sentence?
Lisa Darden's.
And how is it you know that?
Because at the time, Lisa's house, just like Chelsea's and Marissa's or those properties, was facing foreclosure.
And who was responsible for the mortgages on those 3 homes that were facing foreclosure?
K. Richins Realty, or Miss Richins.
You see about 2 sentences down, there's a reference to Lotto and his house in Hideout.
Yes.
Did Michael Kelly at that time own a home in Hideout?
Yes.
At the end of that paragraph, you see a reference to the Yotels.
Yes.
Do you understand that reference?
Yes.
What is it?
2 properties at the Canyons Resort that were short-term rentals owned by K. Richins Realty.
And like the other 3 properties, were those 2 Yotel properties in foreclosure at that time?
Yes.
The next paragraph asks, one way to get at Katie is going through my phone and finding pictures of her girl.
Yes.
Based on your investigation, did the defendant's mother, Lisa Darden, at that time have access to either a copy of the defendant's phone or a new phone that contained the information from the defendant's phone?
It appears so, yes.
I object. He doesn't have any direct knowledge of that. Speculation.
Yeah, we lay a little foundation. I'm not sure what he means by it appears so.
Sure. How do you know that the defendant's mother, Lisa Darden, at that time had access to information from the defendant's phone?
During several other instances of calls or text messages between Miss Richins and her mother, she frequently asked her mother to retrieve data or information from, quote, her phone.
And based on that, and based on that request, and jail calls, did Lisa Darden appear to retrieve information from the defendant's phone?
In reply, yes.
On page 5, the letter references my girls and then Chelsea, Kelsey, and Selma. Based on your investigation, who are Chelsea, Kelsey, and Selma in relation to the defendant?
3 of her closest friends.
Finally, turn to page 6, please.
See, what I don't understand is she was so in debt, and I don't know if he knew how in debt she was, but the whole fight with them began when she bought that mansion, because he knew that he was going to have to bail her out and give her money in order to flip it. So he knew she didn't have any money to put into the work that it needed, and it needed a lot of work. They ended up selling it too, by the way, and it was still needing work when they sold it because they didn't touch it while they had it. But at least I wonder how, when it sold, I guess, I'm sure she didn't get anything from it. She didn't make anything off of the sale of it. She probably lost money on it. And we may have covered that, but I don't remember exactly.
In the middle, it reads, lastly, don't forget to work on the gun receipts. We want to file charges and let the prosecutor not do anything about it.
Yes.
Based on your investigation, what is this business about gun receipts?
Miss Richins.
I'm going to object. I think he's identified the names of the people. I think now Your Honor can read the rest of this letter. There's nobody else to identify in here.
I think I can draw an inference on that one, Mr. Bloodworth, but you can move on.
I suspect the court can draw an inference on crest white strips as well, so I will stop there.
Okay, very good.
Thank you.
Oh, so she can beat a dead horse, but he can't.
Ms. Lewis, any follow-up for Detective O'Driscoll?
So, one moment.
Of course.
Your Honor, we don't have anything further.
All right. Detective, you can step down. Thank you.
Yeah, I like him too.
Detective O'Driscoll, you've testified to this before. As a part of your investigation, did you contact representatives of the hunting camp in Mexico where Eric Richins hunted?
Other investigators on the case did, yes.
I object. I don't know where this is going. It doesn't seem to have anything to do with what's in front of the court right now.
I have similar questions. Tell me where we're going.
Your Honor, the court has heard this testimony, and that the testimony.
Stop there, though. Why do we need to get into this today?
Your Honor, because the defense has argued, not only in its moving papers, but in some of its questioning today, that this business about the hunting camp was a discussion between Ms. Lazaro and the defendant.
How would this gentleman know whether that is the case or not?
He would know that that discussion is inconsistent. The purported discussion between Ms. Lazaro and the defendant is inconsistent with the facts of the case that Ms. Lazaro had at the time. I'm also mindful of burdens here, Your Honor. The defense, of course, has the burden, right, to
showing that this is either privileged or protected from disclosure as work product.
Correct, and they have presented no testimony on that issue. Nevertheless, the state could present testimony right now regarding the investigation into the hunting camp.
Yeah, let's stop there, though. The hunting camp issue potentially opens several different cans of worms. I'm going to limit you on this topic today. We'll see if we ever need to get into this prior to trial.
Yes, Your Honor, understood. Can I propose this? To the extent the state, because we haven't seen substantive papers from the defense, right? To the defense opens this can of worms.
Understood.
Can the state rely on Detective O'Driscoll's previous testimony on the issue in its responsive papers?
Sitting here today, I can't remember if these lawyers were present when he testified to that.
It was the previous set of lawyers.
Okay, I'll consider that.
Okay.
Still not sure this is ever going to come up on this motion, but we'll see.
So I appreciate that. I'm not sure either.
So that's even more reason to move on.
Fair.
Okay, anything else for this witness?
No, sir, thank you.
Ms. Lewis, may we let this gentleman step down?
Yes, Your Honor.
Okay. Mr. Ramos.
No, Judge, thank you.
We need to talk about deadlines. I am happy to let all of you talk amongst yourselves, agree to some briefing deadlines, and tell me what they are when we convene on February 3. Is that agreeable?
Yes, Your Honor.
Yes, Your Honor.
Mr. Bloodworth?
That's agreeable, Your Honor. I would just ask, because I've seen the court do it both ways, is the court's general preference for kind of a more substantive briefing from the defense, followed by opposition by the state and reply?
I mean, you all can stipulate around whatever you want to do. To the extent people want to have the last word on the issues for which they have the burden, I don't know that I'm going to say no to that. That can create some lengthy back and forth. So just talk to each other, see if you can agree to what's going to happen here. I would prefer to receive all the briefing, be able to read all the briefing, and then have a hearing where I can ask you questions about it and have you make your arguments after I've seen it. That works best for me.
Yes, sir.
Okay. Talk to each other, though, about a timeline for that, and let me know what you decide on February 3. We are reconvening on February 3 by WebEx, I believe, at 9:30 a.m. to discuss juror questionnaire related topics. Is that correct?
Yes, sir.
Okay. Ms. Lewis, is that your understanding?
If that's the case, maybe the trial's going to be a lot sooner than April. I don't know. I just saw on the internet, though, it said that somebody said Court TV has it that the trial date was set for April, like the end of April. Okay. Let's go over here. We're going to hear Driscoll's full testimony, what he did a little bit before all this happened. We've got his testimony. I'm sorry, not Driscoll, O'Driscoll. And then we've got the testimony of Eric's brother-in-law, his sister's husband, and it's the sister who had control of the estate. But first, we're going to Detective O'Driscoll.
Supervisory changes to the investigations division as well.
And when you say her case, you mean the case at that point in time investigating the death of Eric Richins?
Correct.
What was the change to not only you as the lead investigator, but you said, I think, the supervision of the division?
There was a new sergeant over the detectives, the investigation division, Sergeant Hoffmeyer.
So I take it you determined to then personally call on the defendant on April the 14th, 2023?
Correct.
And why personally instead of over the telephone?
It had been a year since Eric's death. I felt it was more professional considering the loss that she had gone through in the family, and felt that it was more appropriate to show up in person to speak with her and to introduce myself than over the phone.
Okay. There came a time then when you appeared on the doorstep of the Willow Court home where she was then residing. Is that correct?
Correct.
And thus began your interaction with her on that day, right?
Yes.
Did you record that interaction with her?
Yes, I did.
How did you record it?
I had a audio recorder running, and then later I activated a body cam that I had with me.
Okay. Let's talk about the body camera. When did you activate it?
After we were invited into the home and asked to sit down.
And did you activate it roughly contemporaneously with the point on the body cam, or the point on the recording where you say, "Do you mind if I record this interview?" or something to that effect?
Correct.
Can you please describe the body camera, not only how the body camera itself looks, but where it was sitting in relation rather to the defendant?
Yes, I wasn't dressed in a law enforcement uniform, and so I didn't have a mount that's typically available to officers to mount their camera to their body. I just had it loose. It's a small square black body cam that's similar to those worn by patrol officers at that time, and when I activated it, I sat it on the armrest of the couch between myself and Miss Richins.
Was it in Miss Richins' plain view the entire time it was active?
Yes.
Does the body camera itself make any noise or light?
Yes.
What noise or light does it make?
It beeps and vibrates every few minutes, and there's a red flashing light that also indicates that it's recording.
And would Miss Richins, the defendant, have been able to see from the location of the body camera vis-a-vis her the blinking red light and hear the vibration and beeping?
Yes.
You mentioned it was similar to body cameras that officers on patrol wore at the time. Was it similar to the body cameras that the officers on patrol were wearing while they interacted with the defendant in the early morning hours of March the 4th, 2022?
Yes, at least some of them were wearing the same body camera.
Have you reviewed both the audio recording and the body camera recording that you made that day?
Yes.
Are those recordings true and accurate?
Yes.
Did there come a time when you were on the front stoop of the defendant's home, that she invited you in?
Yes.
And is that accurately reflected in the recording?
Yes.
Did you then, upon her invitation, enter the home?
Yes.
Can you describe how you entered the home, how the home was laid out, and where you and Sergeant Hoffmeyer was with you?
Yes, correct, he was.
Where you, Sergeant Hoffmeyer, the defendant, and ultimately the defendant's mother, Lisa Darden, were sitting?
Yes. So the front door of the home opens into a short foyer. Directly in front of the door, through the foyer, is the main living area of the home. There were couches and love seats in the family room. Miss Richin sat on one end of the couch. I sat on the other end, and Sergeant Hoffmeyer sat in a separate piece of furniture near us. When Miss Darden entered, that Lisa, the defendant's mother, she seated herself on a entertainment center across from the couch on one wall of the living room.
What was your observation of the defendant's mood throughout the conversation?
She seemed very cheery, very open, happy to be talking with us, happy to have the opportunity to talk to investigators. She was outgoing.
At any time throughout your interaction with her on that day, did you observe her cry or become, did you observe tears fall from her eyes?
I didn't see tears, no.
I want to turn.
Okay.
Are you familiar with the emails at tab 12?
Yes.
What are they?
They are emails that Miss Richins sent myself and Sergeant Hoffmeyer a few days after we spoke to her in her home.
Do those emails follow up on the conversation and interaction you had with her on April the 14th at the home where she resided?
Yes, she was providing us additional information, follow-ups to the things that we had spoken about in her home.
And are they true and accurate depictions of those emails? You don't see them altered at all?
No, not as far as I can tell.
I asked you two questions, which was sloppy form. Are they true and accurate depictions?
Yes.
Were they altered at all?
Does not appear so.
Thank you. No further questions.
May it please the court. Good afternoon, Detective. We've met before, but Kathy Nestor again on behalf of Ms. Richins. All right, so I want to talk to you about your deciding to go visit Ms. Richins. And you said that you had just been appointed, or not appointed, but assigned to the case, right?
Correct.
How long before?
I'm not sure. Less than a month, I think.
And when you were assigned to the case, there was a case file, wasn't there?
Yes, there were different locations that information about the case were stored or recorded.
All right. And you've been a law enforcement officer for some time. I'm certain you didn't go to her house unprepared to interview the primary suspect of a murder, right?
No, not entirely unprepared, but again, the intent to go to the house was not solely to get an interview. It was mainly to introduce ourselves and the change that had happened with the Eric Richins death investigation.
How long would that have taken?
I'm sorry, how long would what have taken?
An introduction.
Not long.
Okay, how long were you there?
3 hours.
Right. Okay, so before you went to her house, isn't it true that the day before you went to her house, you had applied for an affidavit for a search warrant of her phone and a computer?
I'm not 100% positive on dates.
Your Honor, can I approach?
Yep.
I assume the
Here it is.
application.
I'm sorry. The affidavit was on the...
I don't know
May
if
I
Mama
approach
said
her?
anything about
Yes, thank you.
if the attorney should be there or not.
And Your Honor, if we could just mark this really quick as 150.
Well, Your Honor, that's Exhibit 9 in the state.
Oh, Exhibit 9, great.
He's got a binder with Exhibit 9.
Great.
Yeah, I can use this if it's in here.
This attorney, she's kind of, I don't know.
Okay, if you could turn to that Exhibit number 9 in the binder and just look at that for just a moment. And is the affidavit along with the search warrant there in tab 9 or just the warrant?
It has the affidavit.
Okay, can you go to the last date, the last page of the affidavit, and tell me the date that you executed it?
It says executed on 13th day of April 2023.
The day before you interviewed Ms. Richins, correct?
Correct.
And in this affidavit, you have multiple pages of why you want to search her phone, right? It looks like basically two pages of facts to support your affidavit.
Yes.
Single spaced. And in this affidavit, you refer to things that happened on the night of Mr. Richins' death and things that Kouri had told detectives before you. Is that right?
Yes.
And things the toxicology report had recorded, right?
Yes.
And you refer to an interview that was done of a friend of Ms. Richins that you refer to here as CB, as in boy, where she had been interviewed and that you suspected she had deleted messages, correct?
Yes, that's correct.
And did you interview CB, or are you referring to what someone else did?
I believe in this affidavit I was referring to an interview that was conducted, that I did not conduct. That was conducted by other officers.
CB is Carmen, right? The one that got the drugs for her? Does anybody know?
And specifically Detective Woody, correct?
I believe from my recollection it was Detective Woody and Sergeant Davis.
And she was in charge of the case before you?
Yes.
And you obviously had access to her notes or someone's notes from that meeting with Detective Woody and CB, right?
I don't know if I had access to notes from that interview with CB at that time. From my recollection, what I knew about that interview came from oral statements from Sergeant Davis and Detective Woody.
So you talked to Detective Woody about this case?
Somewhat.
How often did you talk to her?
Not very often.
When did you talk to her first?
I don't recall.
Before you interviewed Kouri Richins?
Yes.
All right. So before you interviewed Kouri, you had enough information about the case to prepare a 2-page affidavit with specific facts that had happened in meetings with Detective Woody, right?
Enough for this affidavit, apparently, yes.
And did Detective Woody provide you with her file from the case?
Again, there's not one file, but yes, I had access to the information about the case.
That she had put together?
Yeah, I mean, even from the beginning of Detective Woody's investigation, from what I understand, it was a collaborative effort of multiple investigators.
Somebody tell her it's a box file. It's a box of files. It's a box fort. Somebody tell her.
Okay, but you had what she put together.
Yes.
And you talked to her about it.
Not about all of it, but some of it, yes.
Okay. And you certainly looked at it before you did this sworn affidavit to a judge, right?
Again, not all of it, but some of it, yes.
Because you don't have personal information. You weren't at this meeting with Woody and CB.
No.
Okay. So would you agree with me, sir, that in this affidavit it is extremely clear that Kouri is a primary suspect of this investigation?
I would have to take time to read the whole thing to answer that. I
Please
can if
do.
you want me to. Okay, I've read the whole thing. Could you repeat the question for me?
Yes. Would you agree with me that when you prepared this affidavit that it was clear that Kouri Richins was a primary suspect of your investigation?
No, I wouldn't agree with that statement.
You would not?
No.
You didn't think she was a suspect at this point?
I didn't have definitive information that she was a suspect.
Okay. But you wanted to look in her phone, and you were asking a judge to let you look into a phone, right? Her phone.
Correct.
And you're asking to look into her phone, by your own words, to see if she tried to obtain fentanyl on her phone.
Yes, that's the part that's recalling my memory is at that time, with the limited information I had, the most important fact that I felt we knew was that Eric died of fentanyl overdose. So the biggest question to me was how the fentanyl got into his system. And in my opinion, there were basically 3 different ways that Eric could have died of a fentanyl overdose. It could have been an accidental overdose, it could have been a suicide, or it could have been a homicide. In order to be thorough, I was trying to investigate all 3 of those possibilities.
So 1 year after he died, you still had no idea whether it was a suicide, a homicide, or an accident?
That's correct.
Okay. So you show up to have this friendly introduction with Ms. Richins. Do you tell her that you had just applied for this affidavit?
No.
And when you say you started from scratch, I mean, you didn't start from scratch. You'd spent a month reviewing the information prior to talking to Kouri, right?
No. I had not spent a full month reviewing that information. I still had a full caseload besides this case. When my time permitted, I reviewed what I could.
Okay, so you reviewed the files, right? Enough to do this affidavit.
Enough to submit this affidavit, yes.
You had talked to the previous case investigator, right?
Yes, but not a full debrief of the case.
Okay, but you'd talked to her, right? You'd reviewed the ME report, because you just said that.
Yes, I have.
Right? Had you looked at the material that was taken off of her phone previously?
No.
All right, so you show up, you don't tell Kouri that you just applied for a warrant to search her private information. Actually, what you tell her is that you all coach soccer together or something? Is that what you said when you came on to the house?
Your Honor, let me kind of renew this objection. What he told her is documented in audio and video recording. There's no dispute. It's not a game of gotcha. It is what it is.
Are you just trying to jog his recollection, lay foundation, or can we just move on?
All 3.
Okay, thank you.
Can I just get him to answer that one question? You talked about the fact that you all had ties in the community through soccer coaching and things like that, right?
Correct.
And then maybe she knew your wife or something?
That sounds familiar.
Okay. But you didn't tell her you were investigating her for homicide at any point in those 3 hours?
No.
You also didn't tell her you had a hidden recorder on your person, did you?
It wasn't.
Can you be specific at which
Yes.
point in time you're talking about?
When you first arrive at her house. Thank you, Your Honor.
No, the intention was not necessarily to hide it. The audio-only recorder was brought as redundancy in case of failure of equipment technology.
Where was it?
In my pocket.
Okay. Did you tell her
It wasn't
there's-
visible to her.
Right. Did
But
you
my
tell-
intent was not to hide that I was recording her.
Okay. Did you know whether Sergeant, it's Hoffmeyer, right, that was with you?
Correct.
Did you know whether Sergeant Hoffmeyer had a hidden recorder on him?
So our memories have been a bit confused on this point. Originally, I thought I had remembered that he had the recorder. The recorder was his piece of equipment and tools, but I think after listening to the recording from how far away he sounds from the microphone, I think I had the recorder on me, but it was just the one audio recorder and the one body cam.
And you intended to go in there and ask Kouri questions directly about what happened with her husband's death, didn't you?
After she invited us in and consented to having us interview her, yes.
When she invited you in, did you Mirandize her?
No.
Right. Did you know she had a lawyer?
No, I did not.
You did not? All right, let's look at the transcript for just a moment. I believe it is number Exhibit 11 in front of you. And can you go to page 7? And can you, this is, I mean, literally, you guys have maybe exchanged pleasantries and you've only been there like a couple of minutes at this point, if it's page 7, right?
Yeah, it looks like about the time we were sitting down.
So what is, can you read what Kouri said to you on line 3 of page 7?
So my attorney has been pushing to, obviously we just wanted her off the case because we're not getting anything done, anything accomplished.
And who's she talking about wanting off the case?
I think she was referring to Detective Woody.
So minutes into your meeting with her, she advised you she had an attorney.
Yes.
And you knew that you were going to elicit information from her that could be used against her, did you not?
I didn't know what information she would provide. I just wanted to know the facts surrounding the night of his death.
If she had said, hey, I killed my husband, would you have used that against her?
Likely.
Okay. So you didn't Mirandize her at that point. You knew she had a lawyer. You knew you were looking for information about her involvement in her husband's death, and you did not Mirandize her, correct?
Correct.
Did you tell her that she didn't have to meet with you, that you were only there if she wanted you to be there?
I don't remember the exact words that were exchanged before we entered the house, but I didn't say that specifically, no.
And you didn't record those, did you?
Yeah, they're recorded on the audio, just not on the body camera.
Okay. Were you wearing a gun?
I think so.
Was Sergeant Hoffmeyer in a uniform?
I think so. I don't remember specifically.
Did he have a gun?
Probably.
Okay. Prior to your meeting with Ms. Richins, when you were applying for the warrant of the phone that had been seized from her in April of 22, did you review the reports about the seizure and the investigation on the 12th?
No.
When you were reviewing Agent Woody's file, do you recall seeing correspondence from her attorney, from Kouri Richins' attorney, instructing that no one investigating the case interview her client again without the lawyer being present?
Your Honor, objection. That wildly mischaracterizes the correspondence. The correspondence is in evidence. It says what it says.
Would you rephrase the question?
Do you remember reviewing correspondence from Ms. Richins' attorney
Why don't we just pause there?
in Detective Woody's file?
There you go.
No.
Do you remember discussing it with Detective Woody?
No.
So prior to going to interview the key suspect of a murder investigation, you didn't take 1 minute to check and see if she was represented by counsel after a year?
No.
Okay. All right.
Your Honor, the state's going to object to this line of questioning. The state renews its objection based on the Sixth Amendment, in that the Sixth Amendment has not yet attached.
So you say, but we're going to have to get into some briefing about whether this proceeding had reached a quote-unquote critical stage under the case law and whether it had begun to focus on a particular suspect or other critical stage. Let's just get the facts in.
Okay. Thank you, Your Honor.
Your Honor, let me make the record.
Sure.
Then let me finish the record on the Sixth, quick move to the Fifth.
Sure.
I think the Sixth Amendment case law in Utah, the Padaki case, says it attaches at arraignment. And so I think it is a clear decision that there is no Sixth Amendment point. The Sixth Amendment has not attached at this point in the narrative. Moving to the Fifth Amendment. Your Honor, the Fifth Amendment, of course, attaches when there is a custodial interrogation.
Truth.
And Utah's Perea case, really citing to McNeil v. Wisconsin of the Supreme Court, says one cannot anticipatorily invoke a Fifth Amendment. You need custody before you can invoke the Fifth Amendment. And so all this business about whether the defendant was represented, whether Detective O'Driscoll knew she was represented or otherwise, is immaterial.
To the Fifth.
To the Fifth.
Not necessarily to the Sixth. We'll see if your citation to Utah case law is correct. But I understand your point regarding the Fifth. I think the Fifth Amendment issues, right, are why they keep asking her if he had a gun on and show of force, free to leave, Mirandized, all that stuff.
Correct. I believe that line of questioning goes to the Fifth Amendment argument.
Correct.
They will one day make.
Right.
But here's the state's concern is the state is certain that we can select a fair and impartial jury from Summit County potential jurors. But the state is very cognizant that the more information, and in this instance, the more false information put into the potential jury pool will make it more difficult and take longer to select those fair and impartial jurors.
Well, I have shared this concern generally in this case from the detention, the first detention hearing, given the level of media attention. But the reason I don't think that that cuts one way or the other with respect to Summit County versus Salt Lake County versus, candidly, Washington County is because the outlets that are covering this, 95% of them are national or international outlets or new media outlets on YouTube that do not respect any county boundaries. And so I think the concern you're expressing, while valid, applies to every potential jury pool.
Well, yes, Your Honor, I agree with that. I think we will argue that one day in the future. The reason I mention it is the gratuitous publication of false information through the course of these moving papers and this examination is unhelpful to creating and quickly filing a fair and impartial jury, whether it's Summit or Salt Lake or wherever.
I appreciate your concern. I don't think we are even approaching, never mind beyond, the point of no return in that regard. And I'll stay aware and vigilant.
Thank you, Your Honor.
Okay.
While he's bringing up the whole jury thing, I wanted to read you guys an article here that was put out by Summit County Park Record is the name of the publication. And it said that next month, the Utah Supreme Court is scheduled to hear oral arguments from the appellate lawyers representing the Summit County Attorney's Office and Kouri's legal defense, asking justices to reverse a ruling made by 3rd District Court presiding judge Laura Scott. Prosecutors and defense attorneys want to pull prospective jurors from 2 counties, Summit and Salt Lake, and also hold the voir dire, which is the questioning of the jurors, in person instead of online. They filed a joint petition asking the Utah Supreme Court to hear their case last month. Now the oral arguments have been set for 10 a.m. on February the 11th at the Matheson Courthouse. So they're still up in the air about that. So we'll find out about that pretty soon.
Just pointing out, Your Honor, all of these materials have come from the state, and this is the first.
Esther, we can just move on.
Okay.
Thank you.
Thank you. All right, so I want to move now to the search that you did and the arrest. By the way, Kouri was arrested. You sought an arrest warrant for her within a couple of weeks of having this start from scratch interview of her, right?
Yeah, that time frame sounds correct.
So in the space of your interview with her on the 18th, whatever the date is, the 14th, and her arrest on May 8th, which is about 2.5 weeks, in between that time, you decided it was a homicide and she was the one who did it. And that's
Yes.
3 weeks. Okay. All right. So then you apply for a warrant of her house, which you applied for on May 3rd.
Please proceed.
By the way, in that period of time between when you had this interview with her and were open to hearing however it happened, the death, and the time you issued the warrant for her and the search for her house and her arrest on May 3rd, did you investigate any other potential suspects in that 2.5 week period of time?
To an extent, yes.
And I assume you have reports about that?
Yes.
That you prepared? Okay. I'm not going to go into that, Your Honor. Okay, so what is the date that you applied for the search warrant to go search her home? When did you ask a judge to give you permission to search her house again, a year later?
May 3rd, 2023.
Okay, so again, like less than 3 weeks after you interviewed her, right? And in this interview, I mean, this
One
warrant.
second, would you repeat that for us?
I just said I believe that math works out. Yes.
Okay. In this warrant that you got, you asked to search for 2 things in the house, right? 2
Correct.
things. Counterfeit pills and copper cups. That's it.
Yes.
Okay. And that warrant was issued by a judge, correct?
Yes.
And that's the warrant that gave you authority to exercise a search of her house on the day she was arrested, correct?
Yes.
All right. On the day she was arrested, Ms. Richins was located in another location from her home. She was down in Salt Lake, is that right?
Yes.
And you were there at the location where the arrest took place, right?
Correct.
And other officers or deputies were involved in the search of the house up in Camas.
Correct.
Right. While you were arresting Ms. Richins, when you arrested her down in Salt Lake, did she have a phone on her at that time?
Yes.
On her person?
It was in her hands, yes.
And when she stepped out of the car, what did you tell her to do with that phone?
She didn't step out of a car.
You pulled her out?
No. She was exiting a business building.
Okay.
And I approached her while she was walking out.
Sorry, my bad. So when you approached her, what did you tell her to do with the phone?
I didn't tell her to do anything with the phone.
What did she do with the phone?
Your Honor, objection. This seizure is not the subject of any of the 3 motions that today's hearing set for.
I think that's right. Isn't that right?
No, it's relevant to Mr. Ramos's motion.
Electronic data?
Yes, because I'm just identifying the foundation of where that phone came from.
Your Honor, that motion, the electronic data motion, challenges the 4 corners of the warrant itself. The actual seizure of the phone is irrelevant, other than the fact that it was seized pursuant to that warrant.
Yeah, forgive me. I listened back to our discussion regarding burdens. Is there anything about the execution of that warrant that defendants believe was unreasonable?
About the execution of the warrant of arrest?
The search warrant, or is it that you believe the phone was seized without the benefit of a
I'm
warrant?
about to get into the statements she made at the time of her arrest prior to Miranda that directly deal with the phone that was in her hands. So I'm just laying a foundation for which phone it is and what they say to her and what they get her to say.
Your Honor, none of that information is relevant to the 3 pending motions.
Yeah, forgive me. This is new to me. I don't know that have you filed a Rule 12b3 motion that regards this? Yeah. We just need to make sure the state had noticed that this was coming. Correct me if I'm wrong, Ms. Nestor. I believe it's undisputed that Kouri was arrested. A phone was seized from her during the course of the arrest.
Right.
2 hours later, a warrant was issued with respect to the contents of that phone, correct?
Right. We are not actually challenging the search of the phone. I am dealing with the issue of the statements that she made after her arrest, but
That topic is not, and forgive me if I missed it, that topic is not a part of Mr. Ramos'
hold on just one
motion.
moment, Your Honor.
Yep,
Can I talk to
no problem.
Okay. I'm sorry, Your Honor, I got confused. I don't need to go into that. So I will move on. That is a different issue.
Okay, very good.
Okay, so you're down there, you're with her when she's being arrested. Meantime, there's officers searching her home up in Camas, right?
Correct.
And at some point, you get a phone call from one of the officers on the scene, is that right?
I don't recall. I'm sure I took lots of phone calls that day.
Did they advise you that they had found something in the search that was not within the permission of the warrant?
I don't recall.
Recall being told?
Go ahead, Mr. Bloodworth.
Your Honor, I think this goes to the seizure of the orange notebook, which is issue 4 in the defense motion to suppress statements and evidence.
Right.
As we discussed last Thursday, the state has conceded that the state seized that notebook on May the 8th, 2023, beyond the scope of the warrant that Ms. Nestor is addressing?
Correct. The state, I understand, will be arguing inevitable discovery.
Yes, Your Honor, and that argument relies exclusively on paper, various warrants. Their tabs, I think it's...
We'll get there. We don't need to name them all now.
13 through 17-ish.
Okay.
The point being is this examination is nothing more than to prove a fact that the state has conceded.
I think that concession matches my notes after re-listening to the last status conference with counsel. Anything else we need from this witness regarding the orange notebook?
Yes.
Proffer for me what else it is you need.
Your Honor, all the steps that are made and the chronology of the steps that are made about the search file into my entire fruit of the poisonous tree argument. I need to lay a foundation if I ever need on appeal. I need to be able to make clear the steps that they went through to...
With respect to the orange notebook?
Yes.
Once they have it, though, outside the scope,
yes,
it's a problem that they now need to invoke some kind of exception to fix. Isn't it the steps after the orange notebook that would be relevant to the fruit of the poisonous tree?
That's what I'm getting to right now. I just asked him about the orange notebook and what he does next. I mean, that's where I'm going.
My apologies. Okay.
No worries. Okay, so may I proceed? I'm sorry. So you get this call that they find a notebook in her house, right?
I don't.
Go ahead.
Your Honor, I don't know that we're fully clear on this issue.
Let me sound out what I understand is the possible benefit of this. Are you preserving the ability to argument that there was a gap in time between when the notebook was actually found and when it would have inevitably found?
Yes.
And during that gap in time, they learned some things that is
Yes.
fruit of the poisonous tree?
Yes.
Here's the gap I'm not sure we're square on, Your Honor. State has conceded that the search on May 8th that discovered the content of the orange notebook was beyond the scope of the initial May 8th warrant to search the home. Based on information obtained from the orange notebook.
At that time
on May 8th, there was a second warrant written to search the home on May 8th for a notebook. The state is conceding that that second warrant, the portion of that second warrant to search for notebooks, there were other collateral issues that don't touch on this, was invalid because it relied on information discovered in the notebook pursuant to a search beyond the original warrant.
Okay.
The state's inevitable discovery argument is about warrants that occurred way after May 8th. All the information those warrants relied on are in the affidavits of probable cause for those warrants.
May we pause here for just a moment? I think this discussion would be more detailed and fruitful if you both weren't worried about seeding the public record with a bunch of stuff you don't want potential jurors to know about. That is a sufficient basis to close these proceedings briefly to have a more detailed discussion about this topic. So, everybody who is on that side of the bar, including all of you, I need you to step out now.
He has spoken. So he basically sends them all out of the room. They cut the feed, and it picks back up where they're bringing in a new witness. So I guess they decided that's it for now. Boom. Yep. He said, boom, mic drop. All right. The last witness that we're going to see tonight is, again, the brother-in-law. This is the sister who maintained custody of Eric's trust. her husband's going to be testifying, and it's not a very long testimony.
Beck's link is unmuted. Mr. Bloodworth, sir, you're under oath, correct?
Yes.
Very good. Mr. Bloodworth, please proceed.
Thank you, Your Honor. Your Honor, for the record, the state is called and the clerk has sworn Clint Benson. Mr. Benson, are you familiar with the trust relating to the estates of Eric Richins?
Yes.
And who is the trustee of that trust?
Katie Richins Benson, well, it'd be the Eric Richins Trust. And then Katie Richins Benson would be over that trust.
And what, if any, relationship do you have with Katie Richins Benson?
I'm her husband.
Are you familiar with the Willow Court address where Eric Richins lived?
Yes.
Does the trust own the Willow Court address?
Yes.
Does the trust have control, like physical control over the Willow Court address?
Yes.
Did the trust gain control, physical control over the Willow Court address upon the defendant's arrest on May the 8th, 2023?
Yes.
Who, on behalf of the trust, has controlled access to the Willow Court property?
That would be me. So after Kouri's arrest, locks were changed, cameras were installed, and I have monitored all access to that property.
Okay. In monitoring all access to the property, other than law enforcement, who, if anyone, has entered the property?
We have had Todd Gabler has entered the property.
And let me just break you there. Is Todd Gabler an investigator retained by the state in connection with the civil litigation?
Correct.
Other than law enforcement and Todd Gabler, has anyone entered the home?
We did have one instance where it was a bank matter where someone did try to enter the home. Law enforcement was quickly called, and he was stopped at the garage man door and garage entrance.
Okay. To wrap a little specifics around that, a bank holding a lien on the property had asked a locksmith to go to the house and change the locks. Is that right?
Correct.
When that person was at the house to change the locks, that generated a call to the police?
Correct.
Deputy Shane Norton responded to that call?
Yes.
And he contacted that locksmith in the garage before that locksmith entered the house. Is that correct?
Correct.
Okay. Other than police, Mr. Gabler, and the locksmith, has anybody else entered that house?
I did have assistance from a family member on installing cameras in that home, but that was right after Kouri's arrest, and that would be it.
Have you personally escorted those who've entered the home?
Yes.
In each instance, I guess, except for that locksmith who was trying to change the locks?
Correct, yes.
Okay. In escorting anybody that entered the home, did you observe anybody bring something from inside the home and place it, or sorry, something from outside the home and place it inside the home?
Never. No, that's never occurred.
Other than police removing items from the home pursuant to warrants, have you seen anybody remove any items from the home?
No.
Thank you. No further questions.
Mr. Benson, you and I have met before, but just to remind you, my name's Kathy Nestor. Okay. So your wife is the trustee of a trust that the house has been folded into, is that correct?
Correct.
And there's litigation surrounding that trust at this time, is that right?
That's
Civil litigation.
correct. Yep.
And since the day that Kouri was arrested, the family was not aware she was going to be arrested, right?
No.
Okay. And she has 3 young sons,
Correct.
and they were at school.
I believe so. I was not there when that occurred, so.
Your Honor, objection relevance as to what this has to do with the state's direct examination regarding security of the home.
Because I think she's laying foundation that there was a time when some stuff was taken out of the home regarding the kids. But I think we could just fast forward to.
I'll get to it.
Thank you.
Okay, I know what the notebook is. The orange notebook. It says that it's just a notebook that she was keeping because her therapist told her to do it. It says physician told her to do it. And I'm not sure what she would write in it, but the officers did open the notebook, read its contents, and then sought an amended warrant for authority to seize it. The defense said that in their court documents that the contents contained physician-patient privilege because they were for her therapist. So that's the big deal in it. But there's no, they've said it's not been disclosed or not if it's clear whether the information it holds is relevant to the case or further to the the Red Rum investigation. So I don't know.
After Kouri was arrested, someone who was not a member of your immediate family was the guardian for a brief time of those children. Is that right?
Correct.
And those children had to come back and get their things out of the house?
I believe so. Yep.
Yeah. And they were with that other person that was not you?
They came to the home, but I believe I was there when they arrived to do that, and they were escorted.
And in fact, hasn't there been, in another matter, hasn't there been an order entered that the children are permitted to go into the home to get items whenever they need it?
They are permitted, but they have not gone to the home.
But at least once they did.
Not to my knowledge.
You just said they went in there with their guardian.
No, you asked if someone had gone to the home, but it was the guardians that had gone to the home to pick up their stuff.
Oh, okay. So the children weren't with them?
Correct.
Oh, I'm sorry. I didn't understand. That's what you were saying. I apologize. So the guardians were there at least once?
They were there once, to my knowledge.
Okay. And Mr. Gabler has been in the home, correct? And Mr. Gabler's been assisting this prosecution with providing them with reports and interviews and all kinds of things to assist this prosecution. Is that right?
Your Honor, objection. Anything Mr. Gabler's provided has been pursuant to subpoena.
We can keep moving here, Ms. Nestor.
Mr. Gabler's working with this prosecution team, as far as you know. He's provided them with materials for however he provided it to them.
Correct.
All right. And he had authority to be in that home because he was working for your family. Is that right?
I wouldn't say he had authority to be in that home. He was accompanied by me when he was in that home.
How many times did he go in that home?
I don't recall the exact number.
More than 5?
I don't recall.
More than 20?
Not more than 20.
Okay, so less than 20 times, but more than once or twice.
Correct.
And when Mr. Gabler would go in there, he did search for items that he thought would be relevant and helpful to the prosecution, didn't he?
I believe so.
Yeah.
Your Honor, renewing the objection.
I think Ms. Nestor is about to move on to a new topic.
And the times that the warrants were executed, we just took some testimony about 4 different warrants that have been executed since Kouri's arrest on the house. 4 times. Were you there for each time they did the warrants?
Yes.
And you saw the searches every time?
I would let them into the home to perform the search.
Okay. And how many people would be in the house, give or take, when that was going on?
You're talking 4 searches, so you'd have to be more detailed.
How many officers would you see? Typically, was it 1? Was it multiple officers that would come in?
It would be more than 1.
So you couldn't be with all of them the whole time, right?
Correct.
How big is the house?
It's 4,300 square feet.
Okay, and there's multiple floors, is that right?
Correct.
Okay. And how long did those searches take, average, when they would go in and search under these last 4 warrants over the past 12 months?
It depended upon the case and what they were looking for. So it was dependent upon the warrant.
And as the trustee, the person that would be present, did they tell you what they were looking for?
No. In some instances they would, some they wouldn't. So
tell me the instances you remember in the last 12 months what they were looking for.
I don't recall exact items. There were a lot of items.
Okay, so they did take items out of the house every time?
I don't recall if it was every time, but they did give a list of items that were taken on the, in regard to the warrant.
All right. And the first time the house was searched, did it appear like was the house in disarray after the search? In other words, were things thrown on the floor? Was there?
Would you pause for 1 second,
Yep.
Ms. Nestor?
Your Honor, this is beyond the scope and irrelevant.
I think this is beyond the scope of the motions you filed. I don't recall any arguments regarding unreasonable execution of a warrant.
No, that's not why I'm asking.
I think we need to move on.
Has Katie been in the house?
No.
Never? Not since the death of her? Not since the funeral?
You got to hold on.
Sorry. Let me
Would you
rephrase.
redefine the time period that you're describing?
Not since the time of Kouri's arrest, Katie has not been in the house?
She has not.
And Amy has not been in the house?
Not that I recall.
And your father has not been in the house?
He hasn't been in the house, no. He's there. You'd have to be more specific. Do you mean the house or the detached garage? What
Anywhere
are
on
you
the
talking
property?
about? He has been on the property.
Okay. Were you present on the day of Kouri's arrest when they were searching the home?
I was not.
Were you the person that came and changed the locks that day, or did someone else do that?
I didn't change the locks. We hired a person to come and change the locks.
So you personally didn't appear at the house that day?
I was at the house.
Were you there while the search was ongoing?
No, I don't believe so.
So do you know how many people went inside and outside the house that day?
Objection, Your Honor.
Sustained. We need to move on.
Do you know you were not at the house the day that the arrest happened?
Your Honor, he
Judge?
just testified that he was.
Yeah, you're going to have to be more specific,
Well,
and we're going to have to move on. You
I
need to
will.
stay
I will.
reasonably tethered to the motions that the defense has filed.
The day that Kouri was arrested, there was a lot of people on the property. Is that correct?
Law enforcement.
And were there others?
I don't remember seeing anybody but law enforcement there, as well as a locksmith to change the locks.
Were you there the entire day?
I was not there the entire day.
Okay. What portion of the day were you there? An hour, half an hour, 6 hours?
Just as long as it took the locksmith to change the locks.
So at the very end, when they were finished?
Correct, I believe so, but I
Okay.
don't recall.
Okay, that's all I have. Thank you, Your Honor.
Anything else for this gentleman?
No, Your Honor, thank you.
May we release this witness?
Yes, sir.
You're welcome to step down. Mr. Bloodworth.
Your Honor, the state has no further witnesses on this first motion to suppress statement and evidence.
And so I believe this is the point where the state would say all burdens either are with or have shifted to the defense. Is that correct?
That is correct, Your Honor.
Okay. Ms. Nestor, Ms. Lewis, Mr. Ramos, give me a sense of where we're headed.
Can I approach for just 1 minute?
Sure.
Mr. Bowles?
Okay, so that was that. That's it. That's everything they showed. I guess he's going to rule on this on February 3rd as to what he's going to do. Teresa, somebody else, was it you or somebody else that said they thought Kouri was flirting with the male attorney sitting next to her too? I don't know. It was Mackenzie last night. Maybe said it too. Mackenzie says, yes, thank you. I don't know if she is or not. I mean, maybe she needs somebody, a male around her she can trust right now. I mean, no, not making excuses for her, but Deanne says, I was waiting for Kouri to jump out of her chair and start asking questions. I mean, my goodness, the same questions over and over again. Oh, yeah, we're going to pray for the judge, most definitely. How long is this? Oh, that's an hour and 42 minutes. So this, maybe tomorrow or Tuesday or something, during the week, we can listen to this Shanna Gardner thing that Court TV's got up. It's like is something about all of her texts being revealed of the years of plotting her Microsoft executive husband's murder. I mean, red rum. I said red rum. I don't know. If y'all want to look at that, we can. I don't mind jumping all over because right now nothing's like. I feel like we're doing good as far as putting stuff out there with Courtney Clenny. I've got her stuff on par. I'm caught up with. I've got a lot more to put out, but I think we're on good timing with that. But I might be giving the judge doe eyes too. He's a hottie. So I don't know. I wouldn't mind it. I was also looking again today at. Oh, that's the one Jose Baez is. Oh, he's on that one. Okay. I didn't realize that he was on that. Oh. Yeah, he's going to jump on that one because it's high profile. I was looking at the Jennifer Gledhill case again today, and they had a hearing. I'm going to look back and look at what we've already talked about on her thing. It's another one who her husband's gone missing, and they believe that she's part of it. And her case is very, very similar to it's like a combo of Kouri Richins and Courtney Clenny put together. It's so strange. So yeah, it's kind of what is it with all these crazy women? That's what I enjoy watching, the crazy women. I think y'all do too. But I'm seeing more of them in court than I am men these days. James Craig, the Aurora dentist who poisoned his wife, was supposed to go to trial this month, but his lawyers quit on him. They quit on him? I wonder why. Jennifer Bloodhill. I don't know that one. Oh, hey, Cher. Well, we've got Thursday night. We have to be over at Laura's channel at 7:30 Central Standard Time to watch her Gacy roll out. She's got a new video to put out on that. New video. So we definitely got to be over there for that. And I was looking at a couple of things I'm trying to put together for you guys too. Some separate stuff I want to put together. There's some of them aren't like necessarily trial cases, but it's just like missing people cases and stuff. Just some things I've been wanting to do. Why not? It's all kind of surrounding the true crime theme. So I thought y'all might like it. Yeah. So Laura, if you have the link up for Thursday night, do you have it set up yet? If you do, put that link for Thursday night in the chat and email it to me. We need to put it on my channel too. Oh, the evidence name says the evidence might be piled too high against him. They let him. That's a good point. Why would a judge let them quit so close to trial date? And the defendant should have had to do something pretty bad, or there was some kind of major conflict they found out about. Okay, Laura just put the link to her video for Thursday night in the chat, you guys. Yeah, often they do, Teresa. The missing persons cases do end up that way. I was just looking at 2 of them today, though, that are old, that it's still out there. It's still open as to, like, people don't know what happened to them. It's sad. Is it better to have closure, even though your family member's no longer alive, or is it better to have hope that maybe they're alive and not here? Can you imagine having to choose between that? Well, and that's the thing, Bama. I'm worried that if I do too many trials at once, I'm going to get them really confused, and I'm going to sit up here and already sit up here and try to talk about stuff that I don't understand. This legal mumbo jumbo. James Craig's lawyer probably quit because he put a hit out on him. I believe it was the prosecutor. Pretty sure. You believe he quit because the prosecutor? Oh, that's right. Drew Peterson. Ugh. That was one guy that I absolutely just from day one. I'm like, what is it that these women see in Drew Peterson? I do not get it. That cute, what was her name? Stacy? Wasn't it Stacy? She was younger than him. She was cute. She could have gotten a nice guy. And why him? It helps me if I see images of the trials of the people on trial, Bama. When I go to look it up, I look at for images, not the actual details of the trial. No, Lacey was Scott Peterson. I'm talking about Drew. Scott Peterson was an attractive man. Drew Peterson, no. Remember, he was the bad cop that got away with a lot of bad things. And he probably should have had some people around him go down too when he went down. Sicko, yeah. I know, I'll get confused too. That's why I'm worried about doing too many at one time, but I'm trying to just kind of, I like keeping up with all of them. I want to do something on the Idaho 4. My problem with that is, though, so many people have been following that from day one, and they're so savvy on that trial. And if anybody comes in here and they listen to me, they're going to be like, you don't know what's going on. This happened, and this has already happened, and they're going to be calling me out in the chat. But I do want to watch it, though, because I am interested in that one. And if it's going to be streamed, then I definitely want to watch it. I wonder if it's going to be a long trial. I bet it will be. And I don't understand this whole thing about them trying to keep out the evidence as far as like recently with the Idaho 4 case, you guys, what occurred was the judge was getting frustrated with the defense because they're trying to get the DNA portion thrown out. Now, the DNA that was found on the knife sheath, is it sheath or sheath? So, which is basically the nice case that sits in the like on his pants or whatever. So they wanted they took the DNA and they did the familiar DNA analysis, right? And that's how they found him, is through the genealogical stuff. Well, they're trying to say that that's not relevant and that shouldn't have been, they shouldn't have been allowed to do that or something. And if anybody's watching this trial and I'm saying anything that's true, please let me know, because I think that's what I understand that's going on. Oh, Bama, my paper calendar is my savior in all things, yes. Not, I mean, in all things true crime. Drew Peterson was 47 when he dated 17-year-old Stacey. Oh, he's so gross. He's so gross. He didn't even have money, you guys. It wasn't like he was Donald Trump, He didn't even have money. So, what is it about him that he was able to get these younger women? And she even had known, she knew about the dead wife before. Did he ever get, whatever happened with that? Did he get found guilty for that too? Yeah, Pam says, no money and he's ugly. He was just he was a smooth talker, I guess. Oof. Stop pretty dang smooth to get my attention. She headed to Colorado to stand trial later this year. Kimberly Singler. Oh, Carolina. I can't cover any cases with kids. I do find myself drawn to those. I just can't cover cases with children. I want to, though. Charisma. Thank you. That's the word he has. He has charisma. Ugh. Kinsey says, Kerry, actually, you would easily catch up. So much of it has been sealed. Much of it. Yeah, that's true. Who have followed from the beginning still don't know hardly anything. That's a good point. I mean, I remember when it first came out, I watched all the stuff that came out at the very beginning. But, them going back and forth with the courts over the last year, I have not paid attention at all. Okay, so the FBI got the IgG results by top secret methods and won't tell the defense pretty much. Okay, so they won't tell them how they got it. But if they use the genealogy match thing, then why? I don't understand why that's a problem. I don't understand why they're having a, like, look at the California killer guy. What was he? The serial killer. What was his name? He got caught by that. So I don't understand. Maybe it was just the way that it was all done. It wasn't by the books. They're trying to say it wasn't by the books or something. I don't know. I just, this case is just, I know that Vinny was fussing about not being able to get a lot of information out of he didn't like that everything was so redacted. Vinny from Court TV. And one of the attorneys that was on there, he's like, well, it's not a bad idea so that we could actually find out in court what happened. And I kind of agree with that to an extent. I think they put a little bit too much out in the media these days. It's really, exactly, nothing illegal about genealogy. It's a little, I think they do. With all the, now you have YouTube and you have all of us following the cases and everything. It becomes harder and harder for potential jurors not to hear things. So I just don't see, I don't have a problem with them redacting stuff. It drives me crazy. Like the Richard Allen case. I would have loved to have been able to watch that trial because so much was kept secret. And when they said they're not even showing the trial, I was like, oh, that sucks. But hopefully one day we'll get something, a good documentary on the case that's going to go into the deep of what really happened and what was going on. Because it's still hard if we weren't able, even if, listening to people that wrote notes in court and stuff, it's still hard to follow. Kimberly Singular is about to be extradited from the United Kingdom finally after all this time. And so she's the one that unalived her children. See, the Madeline Soto case, yeah, that's one I don't follow either. Okay, hang on. I'm going down to read y'all's chats. Night, Carolina. Oh, Jean says, I'm on that case like stink on you know what. It reminds me of Letitia Stalk. Okay, so you're talking about the lady that's being extradited from the UK then. This Kimberly Singular, okay. You think Maddie's mom knew? Okay, whoa, what does she know? Maddie's the one that her mom hasn't spoken out much. The one that her parents are speaking out a whole lot, originally it was kind of leaning towards where everybody thought that he had this thing for her because of her social media. But then I started to hear where I thought it was more like, well, did he have a crush on Maddie? Does anybody think that Brian Kohlberger had a crush on any of the girls? Christine, it says, I'm trying to figure out who Kouri Richins' boyfriend was, pictures or his job or anything. Who her boyfriend was? Did they even name him yet? I don't remember. She had a boyfriend, and I thought that was the whole reason why that was like part of the prosecution's case is that they had this evidence that, she was telling him she loved him and soon they'd be together, blah, 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 blah. That was like a big piece of it. Okay, so she said she had to watch Jean says she has to watch a legal channel, explain that all to her because it's complicated and confusing about the investigative genealogy genetics. Yeah, I don't have time to understand. I'd rather somebody just explain it to me in the Cliff Notes. Stefan Stearns, the one that the Madeline Soto guy, he made money from the case already? That's horrible. That is just horrible. Okay, so Mackenzie says they used a genealogy test. We're talking about, by the way, y'all, we're talking about Kohlberger. They used a genealogy test that's based in Israel or something, and the defense is taking issue with that because they know if the state is forced to come out and admit that, it'll look bad on the state. They used a secret informant to get the results and won't tell who. Okay. That still doesn't make sense to me, though. If his DNA was on the sheath that was left there, and through the genealogy, they found the match, I don't see why that doesn't make a difference. I just don't see. Who is Jen? Jen received money from Stefan Stearns. Is that the mom? See, I don't even know the players in that case. Mandy wants to know what the bombs were dropped. Yeah, that's what they're talking about, Mandy, the genealogy. But I don't think they've come to a conclusion on it. The close revealed a lot of wrong details on the probable cause affidavit, and they're going to have a Frank's hearing because of it. Rumor is Brian's sister ratted him out. And the 4 girls snubbed Brian Kohlberger. Well, how do they know they snubbed him? Or was he just there and they just didn't pay attention to it? Like, you know what I mean? Like, you mean either way, they snubbed him, whether they intentionally did it or unintentionally did it. Hey, Route, good to see you. I bet he would be one that would be quiet, and he would be one that you could easily, like, just not get a good feel around. And so he probably did come across as creepy. The closed hearing for BK revealed many inconsistencies on the probable cause affidavit, and they're going to have to do a Frank's hearing. Okay. After what I'm hearing now about the Delphi case, I have my doubts when I didn't before. See? Gene, I so wanted it not to be him, and I don't know why. When I was listening to all the evidence come out, I was like, I was really thinking it wasn't him. I was really thinking it wasn't him. And then when I listened to everything in court, it made sense, right? But now they're coming out with this other stuff, and I want, see? Christine, she wants information on Kouri Richins' boyfriend. I don't. All I know is I have to go back and look at Christine, go watch the first video I did on this case, because I think I outlined some stuff about the boyfriend in that. It's been a while since I did it. But I think because that was kind of when I was laying everything out about what they had against her, why they thought she was apart and everything. Hey, Deb. Oh, it's horrible. Kouri's best friend was her handyman. The FBI followed BK from Washington to Pennsylvania, and that was before they did the genealogy. So they had suspicions, but he was on the radar, but he was on the radar. I'm trying to think of what it was. It wasn't just his car, was it? He was on the radar for something else. And there was even something that happened before Idaho 4 that they were thinking, could he have been linked to it? Defense tried to say that method violated his Fourth Amendment rights. Psh. Mandy said she recently watched Iowa versus Burns, 38-year-old cold case solved using IGG. His conviction held up on appeal. Really? So now they're going to say it's not valid enough. Legal loopholes. That's a shame. I mean, it doesn't get much stronger than that, I wouldn't think. DNA is DNA. And the only way that you can get out of a DNA thing is if you had a twin. Isn't that what they say? Twins have the same exact DNA. Well, it didn't get the California serial guy thrown out. He got convicted on that. They use 23andMe or others when they're not supposed to, is how I understand it. Well, so I thought that was the whole point. You go to that. You're saying there's a bigger lab they're supposed to be going through. Oh, okay. Kouri asked her boyfriend if he could get propofol. Night, Louise. Okay, the FBI isn't supposed to use 23andMe, only systems like CODIS and approved systems. Okay, I get you. All right. Well, you guys you're teaching me something here tonight. Thank you. I agree. I think it's one of those things, Mandy, if it's, I don't see how it could be, I don't see how you could deny it. Oh, okay. So name says even identical twins have a very slight difference in DNA. Yeah, well, the fact that Kouri tried more than once and it didn't work. Like, I think if it had worked the first time, she might have gotten away with it. Like when they were out on vacation. It seems to me like it happening in a situation like that, it might have turned out differently, I wonder. Yeah, it would be tough to be a police officer and know things and have, everything in line. And you just need that one piece to make it click to get what you need. And the channels just aren't lining up for you to get to that piece. Okay. So she wants to know how they got they're the FBI. Should they have to tell her? I'm just kidding. Why is Karen Read so popular? I don't understand. I don't either, Route Irish. I have never, but at the same time, I have never followed that trial. Never. When it came out, I was like, oh, never heard of it. I just know that her boyfriend was an ex-cop or something, and he's no longer, and she's on trial for his murder. That's very interesting. All right. So you guys help me answer Christine's question. Do we know anything about Kouri Richins' boyfriend? Well, hang on just a minute. Let me do something. So the New York Post wrote that she allegedly texted her lover in the days leading up to the husband's unaliving. Hang on. Got all these ads popping up. She sent text message. His name is Robert Grossman. In the 2 days prior to her husband's March 4th, 2022 fatal overdose. They got all that out of her phone because it came from a digital forensics expert. Around that time, Mr. Richins passed away. There were ongoing messages between Mr. Grossman and Mrs. Richmond, or Mrs. Richins. Let's see if they go into anything. They also confirmed that Kouri kept Grossman in the loop about her arrival time when driving to see someone on February the 14th of 2022. Now, that was another attempt, right? That was the first time she tried to unalive him. And then the second time would have been when they went on the trip. And then the third time was when she finally did got away with it, or not got away with it, but she finally did it. She had said that she was on her way to see him in text messages, and he asked if she was about an hour away, and she said yes, and she sent him a screenshot. They began messaging on November 2021, and they continued to after Eric's death. The volume varied depending on the day it was, but pretty much daily communications. A lot of data had been scrubbed from her phone between January and March 2022, including all her calls, text messages, and internet search histories. You know, she was trying to hide everything. She went above and beyond. She was so... This woman is like a... Don't let her looks fool you. She's evil. Okay, it says that she had hired Grossman as a handyman to renovate homes for her real estate company. A handyman. I don't know why I pictured a businessman, but this is interesting. So she meets him through all the stuff that she's doing with her houses. He fixes stuff around the house. She's like, oh, he fixes everything. It's great. I get it. Okay. See, there we go. Does that help, Christine? Yeah, so the poison sandwich was February the 14th, was Valentine's Day. But then was it before that or after that they took a trip somewhere out of the state or out of the country and he got sick too? But, oh, speaking of Black Widow, if you guys have never seen the movie Black Widow, you have to watch it. It's an oldie but a goodie. What's her name? Sissy from Urban Cowboys in it. I forget her name. She played in, well, her biggest role was the one with Shirley MacLaine. I love that movie. Oh my gosh, I can't think of it. The name of it. It's on the tip of my tongue too. It's an excellent movie about the mom and the daughter dies. Jack Nicholson's in it. Help me out, people. What's the name of that movie? Oh, shoot. Such a good movie. It's like probably one of the best movies of all time, in my opinion. Yeah, I knew about the ghostwriter. Laura says on the night of her husband's sudden death, Kouri Richins allegedly received a text message with a photograph of two people kissing, and it came from another man. Terms of endearment. Thank you, Mary Carol Hooper. She was listening. She didn't want to chat, but she's in there. Thank you so much. Yes, Terms of Endearment. Oh, it's the best movie. Texas in charge of investigating Karen, and they said they were looking for nudes of her on her phone. And that night at 8:36 p.m., which was March 3rd, 2022, Kouri allegedly texted the man back saying, I love you, followed by a kiss emoji. Thank you, Miss Laura. Barbara, Terms of Endearment. I knew you'd know Laura, Barbara. Deborah Winger, that's who it is, yeah. Do y'all think Ashley... sorry. I have to go back up. Do y'all think Ashley Benefield will get out on bail now that she's convicted? That one is one of those that it's... the name sounds familiar, but I don't know the case right now on the top of my head. Laura says less than 30 minutes later, according to her own account, relayed by law enforcement officers, Kouri and her husband, Eric, had a drink together. The Moscow Mule. Yeah, okay. That did it in. Okay. Yeah, they keep calling her a Greek both. Yeah, Mandy's, you've been doing that from the beginning. She's like, I hate it when they call her an author. She's not an author. She used a ghostwriter. Black Widow on Google comes up. No, it could be 90s, late 80s, early 90s. And it's Deborah Winger's in it. She plays the cop. Let me look it up real quick. I'm pretty sure that's the name of it, Black Widow. I can't remember the, yeah, the other girl that played it did a really good job too. Yeah, it's called Black Widow, and just Google Black Widow Deborah Winger. Oh, and it's on Prime. I don't know if you have to pay for it though. I might watch that again. It was done in 87. That's y'all's homework. You'll have to go watch that movie, and trust me, you'll thank me later. Hours after that, at 3:21 a.m., Kouri called 911 reporting that her husband was not breathing. He's cold. He doesn't have a pulse. She had a good man sleeping next to her, and she had to get a boyfriend. Greedy wanted that. Well, I think part of it is that her husband probably wasn't. I think they were having problems for a while. They had a lot of disagreements. And I think it all started with when she started doing that business and she started taking money. Now remember, she stole money from him, but then she also had taken money from him where he had, done it legally, and he was getting frustrated over her. So Kouri was a hoe, Cher said. Aren't they all, Cher? Oh, my goodness. Yeah, so do y'all... yeah, good point. Will they bring Grossman to the stand? Absolutely. They've got to. But then they said that they thought... Who was it said they thought that... Kouri plans on testifying? Oh, now Laura's copy and pasting. I can tell what you're doing, Laura. She said prosecutors alleged Kouri, who had started a real estate business flipping houses, owed hard money lenders at least 1.8 over 1.8 million. Yeah, and I think that she purchased that mansion. I think she did it she did it without him knowing. Didn't she sign his name to that? I don't remember if she signed his name on. I know she signed his name to a lot of stuff. And he was like, no, and I think he blew up. But I think he also had a funny feeling about her, too. I don't think he trusted her anymore. They were going to get divorced regardless. Why didn't she just let the divorce happen, I guess it was all the money thing. I guess she found if they did get divorced, he would find out about all the money she'd been taking because he would have had somebody go in and look at all his finances. And that would have been bad. Because remember, she still has these forgery charges open and on the side of this whole murder charge. Where's you can't hear me? You can't hear me anymore? The cat just laid on everything. Hang on. You're freaking me out a little bit, Mackenzie. I'm just talking. Can you not hear me? I'm just going off and off. Grease. Never saw. Oh, Grease the movie? Yeah, that's one of my favorites. All right. Well, you guys, I'm going to call it. I don't know what time I'll come on during the day, either tomorrow or maybe Tuesday, but I've got a couple of things I've put together, and I feel like I need to present it on a live rather than doing a video on it. So y'all get some sleep tonight. Let's get up tomorrow and do some sleuthing. Y'all take care. Love you guys. Bye. Thanks for watching, everyone. If you enjoyed this video, please do not forget to like and subscribe on your way out, and feel free to leave a comment. Have a blessed day.